Hello, everyone. This is Edward Eddie Paul Reyes with Jurax Bar, and today we're going to talk about the 12B6, and we're also going to talk about the summary judgment. And those two sound very similar, and they do have many similar characteristics, but they also have very substantial differences. So we're going to talk about that too. Before we do that, I want to say this, that when you're talking about a 12B6 or a demurrer, we'll just refer to that as a 12B6 or a summary judgment. What we are talking about is this. We're talking about a whole different issue. Think about that. A whole different claim. It's not, because the 12B6 does not stand alone. The summary judgment does not stand alone. Let me place an importance on that, okay? Let's do an analogy here. Let's say you're a male, or you could be a female too. I guess for females it's more common, this scenario. But you interact with a stranger. It could be any setting, right? And throughout the dialogue, the person will say, maybe the woman will say, "I'm married." So what do you do if she says, "I'm married"? Do you just stop the conversation and say, "Oh, excuse me, like I don't want to," right? What do you do? Okay. Here's what I would do. I would consider the totality of the circumstances, the factors. Why? Many reasons, right? But it could be that the person, right, she could be separated. It could be that there's no romantic interest on your part, so it's just a very innocuous kind of conversation, right? You're just conversing, but the point is that you're analyzing the other person. You see that? You're analyzing the other potential spouse, the other potential partner, right? That's all you're doing. And I mentioned that analogy because that's what you're doing for a 12B6. That's what you are doing for a summary judgment. You're looking at the other issue. What are you looking for? You're looking for the elements of the other issue, right? So you actually got to run through the elements. Are these elements met for the other issue? That's what it's all about. So today, we're going to start off with the 12B6, and then in the next video, we're going to talk about summary judgments. So it's going to be 12B6 day. This is just the intro, and let's get right into it. Let's get into the black letter law for 12B6 here, and you can see it. This is from an actual case from McDonald's. It involves McDonald's, and of course there are so many people out there that want to sue McDonald's because, right, they have money, they're insured. And now, what I did here was I just went to Google. I typed in McDonald's 12B6. I think I even used the word Twombly, and this case came out, and it's called, let's see, Beckley versus McDonald's. And I do have notes here. This is the agenda. I want to walk through this. Now, I do want to say this, that when it comes to 12B6 motions, they can be complex, especially if you read the black letter law. Now, the purpose here is, what I want to do is I do not want to confuse you. What I want to do is I want to make this simple enough, because if you look at it, if you study it enough, it is simple. It's not complex. And I'm going to give you some techniques here. But here is the objective. Here is the operation. Here's what you actually have to perform. Okay? What you have to do is you have to analyze two issues. Like I said before, remember, you meet a person and they have a spouse, but don't be intimidated by that, right? And I do want to emphasize the other spouse. Why? Because it's another person, another entity. It's the same thing here. It's the same thing, and I use the other spouse because you can relate to that, right? In a real life situation. And when we're talking about a 12B6, we're talking about 12B6. Yes, it's an issue, but also another issue. There's another issue out there, whether it's fraud, whether it's battery, whether it's discrimination in employment based on age or race, which we are going to see here. But keep that in mind. It's a single issue. It doesn't stand alone. Okay, so that is your goal. That is your objective. Analyze it. How do you analyze it? Here's how I analyze. The formula I use is E plus B plus F. Element plus the word because plus fact. Okay, you would use that for the law school exam. You would use that for the bar exam. Yeah, E plus B plus F. Element plus because, the word plus the, right, plus the facts. What does that amount to? It amounts to an analysis. Do the facts meet the elements? Right, that's what's happening here for the 12B6 at the end of the day. For the bar exam, for the law school exam, do the facts amount, right? Do they meet the elements? For the other issue, right? That's what's happening here. So at the end of the day, even though this right, the wording is complex, we got this. I'm gonna help you. We're in this together. All right, I'm with you. I feel you. I feel you. Okay, so heard it with the black letter law in Civ Pro. It is. Many people are intimidated by civil procedure. Why? Because one of the reasons is because of the black letter law. Traditionally, like for example, in torts, the black letter law guides you. Even in like something like contracts, it can guide you. For example, battery. Do we have intentional? What is it? Offensive touching? Is it intentional? You can use, right? You can use those elements, those prongs. All right. Do the facts, right? Do they meet? You can use it. Now for civil procedure, it's more complex. The black letter law can throw you off. So what we're talking about here is we're talking about two aspects to succeed in civil procedure. One is to understand how the law functions. Independent, right, of the black letter law. Why do I say independent? Am I saying you should not memorize it? Yes, you should memorize the black letter law. But at the same time, understand it independently from the black letter law. Okay, because it has its own functions there, just as I explained earlier. And if we use that black letter law, and if I'm not saying we're not going to use it, we are, but we're going to focus on certain key words. And once we focus on these key words, and then you're going to excel. The law professor, the grade is going to be like, right? It's going to be like, wow, I see the key word, plausibility, for example, which we are going to use for 12B6. You are going to use the word plausibility in the black letter law. And I'm going to show you. I'm going to show you some actual examples that they use in practice and some examples that they use for the bar exam. You're going to do well. Okay, let's get into it. Okay, so let's look at the legal standard here. This is actually a motion. Now, what I do want to say, okay, if you're wondering, how does the 12B6 differ from the summary judgments? I'll tell you right now. For the 12B6, you file it when you get the complaint. You don't file an answer. An answer is a responsive pleading. A 12B6 is an actual motion that can dismiss the complaint, right? So think about that. That makes a lot of difference. We are going to talk about summary judgment later. Summary judgment, a lot of times, especially for law school exams, they'll say, "Hey, look, discovery was conducted." Why do they say that? Because for the summary judgment, they file an answer. Then they may even conduct discovery, right? And if the plaintiff goes through all that, then the defendant can still file a summary judgment, right? But let's not get too much into the summary judgment. What you need to remember is that 12B6 is a motion. You don't file an answer. Okay, you just right off the bat you dismiss it. Okay, so let's get into the language here, and this is standard language for a motion, for a 12B6 motion. So many law firms use this, and it's fine. And again, don't be intimidated by it. I'm gonna show you the key words. All right, here we go. Okay, legal standard. The court accepts the plaintiff's factual allegations as true and construes the complaint in the plaintiff's favor. They're saying, hey, look, the plaintiff, since you filed your complaint and the defendant filed the motion to dismiss, we're going to give the plaintiff the benefit of the doubt. So some of the facts that you invoke, we're going to accept them as true. All the facts? No. And that's what it's all about. You analyze the facts in the case. That's what this 12b6 and the standards are all about. We're going to talk about Twombly. We're going to talk about Iqbal. Okay. And in those cases, they analyze, they provide a standard for the facts. But at the end of the day, remember this, plausibility. Okay. And we'll get into it. Let's continue. In analyzing the sufficiency of pleading, the court is guided by a two-pronged approach. One, the court is not bound to accept conclusory statements of the elements of a cause of action. Conclusory statements. The court, in other words, they're saying, hey, look, we're not going to accept all the facts. If you make a legal conclusion there, we're not going to accept it. Fancy language. Two, where there are well-pleaded factual allegations, the court should assume their veracity and then determine whether they plausibly give rise to entitlement to relief. The word plausible there. I do want you to focus on that word. I do want you to memorize that word, and however you determine that in the way that you construe the 12b6 black letter law. Use the word plausible. Okay, I'm gonna give you some examples. Can you use the examples that I provide? Sure. Of course, but focus on that word plausible. Okay. Then it says, okay, a plaintiff's obligation to provide the grounds of its entitlement to relief requires more than labels and conclusions, and a formulaic recitation of the elements of a cause of action will not do. Okay, so again, they're establishing the standard. It sounds complex. Okay, but until you see how this actually works, then you're going to be like, oh, okay, I see how it works in actual practice. And I'm going to show you how they use the standards, the keywords in this particular case. Let's continue. To survive a motion to dismiss, a complaint need not contain detailed factual allegations, but instead the complaint must contain only enough facts to state a claim to relief that is plausible. Uh-oh, that word plausibility was used twice. That's why I'm telling you, you're going to do well. I'm going to show you, okay, that is plausible on its face. Now let's get into this. Now, what they're saying here, what the plaintiff is saying in this case is that she's saying, hey, look, McDonald's didn't hire me because of my race. Here she goes. Let's just go on here. Her name is, let's see, the plaintiff's name is Eckley. Okay, she's 70 years old, Caucasian, and she's looking for a job, right, at McDonald's in Montgomery, Alabama. And she goes into the store and she meets with the manager named Clarissa, who is black. And then let's see now if there's anything here that is relevant to our discussion here. Okay, so then at the end of the day, Beckley does not get hired. Then it says that she filed the complaint alleging race discrimination and alleging age discrimination. So for people who are into employment law, I'm sure you will enjoy this case. Okay, discussion. Shotgun pleading. That's okay. That's when pretty much shotgun pleading won't be too relevant here, but that's when the facts are not construed with specificity to the point where the defendant, even the court, has to kind of put the pieces together. Okay, what are they trying to allege? So let's not get too much into that. Let's go into employer liability, because here is where it does become relevant. So it says here, McDonald's argues that Beckley fails to state a claim upon which relief can be granted. Again, what does that mean? All right, I'm telling you. Okay, the magic. Okay, the language of civil procedure. Okay, it could serve as well. It can not serve as a guide. Remember how in torts you can be guided, right, by the black letter law. Here, if you try to be guided, it might just lead to confusion. That's why I explained the function. Okay, so you won't have to battle. You won't have to battle with the language. Can you use the language like they did here? Sure, of course, use it. It's very lawyer-like. This is the judge writing this. Okay, So let's continue. What I'm saying here, let's not be intimidated. That's all I'm saying. Okay, so McDonald's argues that Beckley fails to state a claim upon which relief can be granted. Why? Because Beckley, the plaintiff, has not plausibly, the word plausible again, alleged that McDonald's is her employer, as the term is defined in Title VII or the ADA. That's a statute dealing with employment. Okay. But let's focus on this. Let's focus on this area here. Okay, because what McDonald's is saying is they're saying, look, Beckley, even if it is true that you were discriminated against because of your age, because of your race, because you were white and everyone else was black there, even if that is true, right, it still does not meet the elements. Why? Why? Because in this case, because McDonald's was not the employer. Boom. So there goes that case. Well, that's what McDonald's is saying. Hey, look, even to give you the benefit of the doubt, right? Even if you were discriminated, McDonald's is not your employer. Right? So of course they go the case. Let's keep reading, but you guys see what I mean, right? Okay, you're focused on the facts. To the facts, can you meet, using these facts, can you meet the elements? That's what I said at the beginning. That's what it is, right? So in this case, Title VII is the other issue. Remember I talked about the other spouse? Maybe they're separated, right? Maybe they've been missing for 7 years out at sea. Does that happen in actual life? Yeah. Now they want to claim the insurance. Insurance is going to say you got to wait a certain amount of time here. That happens. All right. So, and again, maybe you're right. You're just having a conversation. You're not even interested, right? Maybe you're married too and you're happily married. Okay. But the point is that you analyze the other person, the other issue, the other issues. Okay. So let's keep going here. Let's see now. And I did get a chance to read this case, and I did get a chance to make annotations here, so I'm just skip to that. And you can always refer to this case. Just type in Beckley versus McDonald's. Okay, in other words, okay, so it goes on here. Let's see. In this case, McDonald's argues that Beckley has not alleged sufficient facts to support a claim that McDonald's was her employer. Specifically, McDonald's contends that Beckley has alleged that Emerald was her direct employer, but that Beckley has not alleged any facts supporting a claim that McDonald's, as Emerald's franchisor, could also be considered to be Beckley's employer. In other words, okay, I like when they use in other words, right? Because I think for the bar exam, I think, and even in actual practice, that's what you have to do. Kind of just make things simple. I mean, use the fancy language, but at the end of the day, especially if you're arguing in front of a jury, I think they're human. They're not. Right? They don't. Many of them don't go to law school, and right? And even if they do, right, they don't have to like. Right? It's skillful litigators going to know how to communicate. Right? So I love when they use in other words, because that makes sense and it drives the point home. In other words, Beckley has not alleged sufficient facts supporting a claim that McDonald's is an employer of Emerald's employees. So what does that mean to Beckley? It means that McDonald's is not her employer. That's what McDonald's is saying. Hey, even if you're alleging that you were discriminated on, it wasn't us. So your case should be dismissed. Okay. And then they go on to cite Chick-fil-A. Let's look at this. Let's see how McDonald's uses Chick-fil-A. Nasrallah. Hope I'm saying that right. Versus Chick-fil-A. What happened there? Okay. Again, let's see. Plaintiff asked his supervisor for time off from work to raise money for Syrian refugees. His employer denied his leave and then fired the plaintiff, and because of plaintiffs from Syrian, all right, their national origin, Syrian national origin. Okay, and then they went on to say, hey, look, there's a violation here under Title VII, under employment discrimination, and then Chick-fil-A moved to dismiss. Okay, and then they said, okay, arguing, okay, let's read this. Chick-fil-A moved to dismiss the plaintiff's claim, arguing that as a franchisor, as opposed to a franchisee, Chick-fil-A was not involved in Leonardo's decision to fire the plaintiff. The court agreed, reasoning there are no allegations in the complaint that defendant Chick-fil-A was involved in supervising plaintiff or delegating responsibilities to him or alleging that Chick-fil-A was involved in denying plaintiff's leave request or in the decision to terminate his employment. Okay. Then all this is that sometimes when people file a motion 12b6, the plaintiff is given a chance to file an amended complaint. That happens. We're not going to talk about that today. Okay, let's keep going here. Let's see now. Plaintiff's complaint does not contain a single factual allegation indicating that the franchisor, in this case McDonald's, had any authority or control over their employment conditions. Okay. Let's see now in response. Let's keep going here. Let's see if I annotated anything that is relevant. Conclusion. For the reasons stated herein, defendant's motion here, Beckley's motion to dismiss McDonald's, defendant's motion to dismiss McDonald's from this action is granted. So in this case, the court granted the 12b6 motion that McDonald's filed. Okay, let's go back here and let's look at the agenda here. Approach for bar exams. Let's look at an actual bar exam. Now, in this situation here, this here is from an actual bar exam. And of course, I practice in California, so I use California. I use these statements from the California bar exam. So I do want to give credit to the bar exam, to the California bar exam. This is their intellectual property. And the thing that I want to point out about the black letter law here is that the writer was given a score of 100. All right, to pass in California, all you need is a 60. Like if value score is 60 essays, then you would pass. This person scored 100 because that's how these selective the model answers. That's how that's the score they attain. Answer B. Question 4, July 2017 California bar exam. So let's go ahead and read what they wrote. Now, if you want to copy this, that's fine, because of course they use Twombly and Iqbal, right? Am I going to say that you should copy every single word? No. Why? Because it's impracticable. At least for the law school exam and for the bar exam. Should you take keywords from it? Yes, absolutely. That's what I've been saying since the beginning. Focus on keywords. Of course, I have that technique, carving out the rule. Have I talked about that? But let me talk about it now. Lawyers, right? They're great at this. I call it the 1,000 yard stare for lawyers. They can look at a statute, pick out keywords. How do I know they know how to do that? Because for the bar exam, it's required. Okay, they even have what the practical application. What is that? The PT, the performance test, or the multi-state performance test for the UBE states, uniform bar exam states. Right, and you might have a case there where they just give you like this huge, like the whole paragraph of law, just like we looked at, just like for the 12b6, the standard there, and you have to know which. There's no way you can analyze every single word, so you have to focus on 1, 2, or 3 keywords, and that's what I suggest. Either 1, 2, or 3, not more than 3 keywords, because there's no time, right? So the keyword here is what for 12b6? Come on, tell me, right? What word are we going to use? Plausibility. Okay. So let's see if this examinee used it. Let's go ahead and read it. It says, motion to dismiss on the 12b6. Under Federal Rule 12b6, which controls in the state law diversity action properly brought in federal court, the Supreme Court has held that a plaintiff must allege specific facts that operate to push the allegations over the line from speculative to plausible. This comes from the Twombly and Iqbal line of cases. Plausibility, use that. Then they go on to say a short plain statement, right? I mean, you still need that, but it has to meet the standard. It has to be plausible. Okay. And let's see now. It says again, what is required to survive a 12b6 motion to dismiss or failure to state a claim upon which relief can be granted. See that? Notice that key word, the fancy language, very sophisticated. But it's very. If you try to follow, it's very difficult, right? You have to understand the dynamics, how it functions, and then you can write that all day, and it's like, wow, it makes sense. Okay, can be granted is that the complaint does not allege sufficient facts to make the allegation of fraud, and not cross out of fraud. It could be anything. It could be a fraud. It could be of battery. It could be of discrimination under Title VII based on age, based on race. Remember, two issues. Remember, the woman or the man that you meet that says, right, okay, but I'm married. Okay, that does not end the discussion. That's the whole point of that. Okay, well, are they still together? Or, right? That's the whole point, that you have to stop and analyze that other person or that other issue. I do place emphasis on that, because if you place emphasis on that, it's going to make the discussion of this so much easier. Okay. Does not allege facts to make the allegation of fraud, or insert the issue there. Plausible, again. Look, they used the word plausible twice. 100 answer. So what word are you going to use when you discuss 12b6? You could use many words, many phrases, right? But at the end of the day, use the word plausibility. Now, I do have the cheat sheets here. I do have the collection, right, for the California bar exam. This one is free. I offer this for free. For a limited time, I'm always changing like the offers. So if you're watching this, there should be a link there. Opt in. It is going to require your email, and then you get it for free. Okay. So I hope you, wait a minute. Before I say I hope you enjoyed this video, I got to say that subscribe to this channel, of course. And let me look. Oh, no. Let me look at the agenda here. Make sure I covered everything. Yeah, look at that. I did. Did I need this? I mean, it helps. Yeah, it helps. Whatever makes, my life a little bit more, right, easier. I welcome that. Not gonna lie. Okay, so thank you for watching. Best of luck. If you have any questions, just post them as a comment and I will answer. Until soon.